Hello everyone. Today I'll be discussing the treaty situation between State Aramika and State Botuna. The case facts are seen in the slides here. Now we will analyze the three issues in this situation. Firstly, we'll look at whether Aramika's suspension was legal and whether Botuna's defenses are valid under the Vienna Convention on the Law of Treaties (VCLT). Secondly, whether environmental obligations can evolve into jus cogens norms, thus overriding treaty provisions. And lastly, how do competing principles like pacta sunt servanda, material breach, and jus cogens interact in this treaty situation? To analyze this issue, we will first need to know about the legal principles surrounding them. The first and most important principle is the principle of pacta sunt servanda. This is the fundamental principle of international law, built on the foundation that agreements must be kept. This principle is codified in Article 26 of the VCLT, where the parties to a treaty are bound by it and must perform it in good faith. Now, why is this principle so important? Well, that's because this principle reinforces trust among countries, as they can go into agreements with one another with no fear, since there is this belief that the other country will perform their treaty obligations. It is a necessary principle to prevent chaos and ensure peace internationally. However, there is an exception to the principle of pacta sunt servanda, which recognizes that there is no need for a party to uphold its treaty obligations if another party has already failed to do so. This is known as the material breach principle, which comes from the customary principle of indemplimenti non est idemplementum. This principle is established in Article 60 of the VCLT. It states that for a bilateral treaty, a party is allowed to terminate or suspend the treaty if there has been a material breach of the treaty by the other party. However, this breach can't just be any type of breach. It has to be a material breach. Now, what does this mean? Well, under Article 60, sub 3 of the VCLT, there are two ways a material breach can occur. First, it is when there is a repudiation of the treaty, and secondly, it is when a party violates an essential provision in the treaty that's needed for them to accomplish the objective of the treaty. Now, this tells us that the violation must be of an important provision that's at the heart of the parties' agreement in order for it to constitute a material breach, and that violations of less important provisions will not be enough to be considered a material breach. An example of a material breach of a treaty is seen in the Rainbow Royal case, where there's an agreement between France and New Zealand to have two agents on the island for 3 years. France, however, let them leave earlier, and the court considered that to be a material breach of the treaty as it had defeated the objective of their treaty. Another exception to the pacta sunt servanda principle is the fundamental change of circumstances doctrine, otherwise known as rebus sis sentibus in Latin, where a party to a treaty can withdraw from it or suspend it if there has been a fundamental change in circumstances since signing the treaty to the point where it fundamentally changes the obligations of the parties. This principle has been codified under Article 62 of the VCLT in order to set out the strict conditions that must be met, as it has been misused previously by states for them to get out of their treaty obligations. So, what are those 4 conditions? Well, the first condition is that there must have been a fundamental change in circumstances. And secondly, that change must have been unforeseen by the parties when they signed the treaty. And thirdly, the original circumstances must have been an essential reason on why the parties signed that treaty. And lastly, the change must have radically transformed the obligations of the parties that are yet to be carried out. Next, let's talk about the principle of jus cogens, otherwise known as peremptory norms. These are powerful rules in international law that triumphs over all rules and are universally binding. The most important and relevant article on jus cogens for our treaty scenario is Article 64 of the VCLT 1969, which states that if a new jus cogens emerges, any existing treaty that conflicts with it will be voided and terminated. Examples of jus cogens norms are rules on prohibition of torture. However, there's a very strict requirement for a rule to be considered a jus cogens, which is that it has to be accepted and recognized by the international community of states as a non-negotiable law that no one can derogate from. This means that a large majority of states across different regions must accept it, thus making it a very high standard to meet. Now that we know about the principles involved, we can apply them to the issues involved. The first issue that we will be looking at is whether Aramika's suspension is legal and whether Botuna's defenses are valid under the VCLT. For Aramika's suspension to be legal, it needs to prove that Botuna has committed a material breach. This means that Aramika has to prove two things: that the environmental safeguards were an important provision that was at the heart of the treaty agreement, and that secondly, Botuna's violation defeated the treaty's objectives. So first, we'll look at whether the environmental safeguards were an important provision. In the Gachigovo-Nyagi-Moros case, it was a dispute concerning a dam project, and the court ruled that protecting the environment was an essential interest of the state. Thus, Aramika can then argue that the environmental safeguards in their treaty were the core part of their treaty agreement from the beginning, and they were not just some minor detail. Now, we'll look at whether Botuna's violation defeated the treaty's obligation. In order for that to occur, the Tatna Arika arbitration case tells us that the violation must be so serious that it defeats the purpose of the agreement. Aramika can argue that Botuna's repeated violations aren't just a small mistake that happened once or twice, but a consistent pattern that shows a lack of respect for their agreement. Their main argument would be that the main purpose of the treaty was not only to build a dam, but to do it in a way that was environmentally conscious. Therefore, because Botuna has failed to do so due to the repeated violations, as defeated the objective of the treaty, thus constituting a material breach. To conclude, since both requirements will most likely be met, Aramika will be able to argue that Botuna has committed a material breach of the treaty, and thus the suspension of the treaty is legal. Now, we will look at whether Botuna's defenses are valid. Botuna used two defenses to justify their actions: the doctrine of fundamental change of circumstances, and that access to clean water is now a jus cogens. The first defense they used was the doctrine of fundamental change of circumstances, where they argued that the safeguards were outdated due to climate change impacts. In order to successfully argue for this, Botuna wanted to prove that the change was unforeseen. This depends on when the treaty was signed. If the treaty was signed back in the 70s, then Botuna's argument that it was unforeseen would be stronger. However, if it was signed recently in the 2000s, then the argument would be weaker, as climate change is an increasingly popular concern nowadays. But even if the change was unforeseen, Botuna's defenses would still fail. This is because, as established in the case of fisheries jurisdiction United Kingdom and Iceland, the change must radically transform the obligations of the parties, not just make it harder for it to be performed. Now, these climate change impacts might make it harder for Botuna to perform the safeguards, but it still doesn't radically transform the obligations of making sure the environmental safeguards are followed. The decision in Kapchikovo makes Botuna's defenses much weaker. In that case, the court decided that the essential reason why the parties agreed to sign the treaty was because of the economic purpose and not the environmental situation at the time. Since the main purpose of the treaty was still there, the change could not radically transform their obligations. Thus, the court will find that the essential reason for the Arica-Botuna Treaty was the dam project itself, and that the climate change impact does not change this essential reason. To conclude, Botuna's defense of fundamental change in circumstances will fail, as it did not meet the requirements under this doctrine. Now, we will look at Botuna's second defense of access to clean water, now being a jus cogens norms. This will also answer the question of issue 2, on whether environmental obligations can evolve into a jus cogens norm, thus overriding treaty provisions. Botuna is arguing that clean water access is now a jus cogens norms as the UN General Assembly has recognized it as such. However, UNGA resolutions are considered to be recommendations and are not legally binding on member states. Its purpose is to encourage implementation through political consensus and not to create binding law. Therefore, a UNGA resolution on its own does not create a jus cogens norm. For a jus cogens norm to be created, it must be accepted and recognized by the international community of states as a whole. Currently, no environmental laws are jus cogens norms, as it is a new field and it clashes with a state's sovereignty over its natural resources. However, Botuna can argue that access to clean water is a fundamental human right, as fundamental human rights are recognized as jus cogens norms. And this is done in Iraq and Nigeria, where the court recognized that environmental protection is important for fundamental human rights, such as the right to life and health. The Paris Agreement helps with this argument as well, because it shows that environmental protection is a growing concern nowadays, with the majority of states signing it. While the Paris Agreement does not create a jus cogens norm, it is evidence of how seriously states are taking environmental protection nowadays, especially if issues like access to clean water violates a fundamental human right. By arguing it with this logic, Botuna will be able to argue that since access to clean water is a fundamental human right, denying that access will be a violation of the existing jus cogens norms of right to life and health. If this is argued, they will be able to successfully claim that the dam's water diversion is incompatible with the jus cogens norm of access to clean water. To conclude, to answer the second issue, environmental obligations are not currently recognized as a jus cogens norm. Thus, if Botuna were to claim that access to clean water is a jus cogens norm due to the UNGA resolution that clean will fail, however, the law on this is constantly evolving. There's already a majority support for the Paris Agreement, which shows the growing concern for environmental protection. If Botuna's case is argued with the reasoning that access to clean water is an important component of a fundamental human right, such as the right to life and health, then it makes their claim stronger, as the right to life and health is a jus cogens norm. Therefore, if their claim succeeds, then they will have a valid defense for not fulfilling the treaty obligations, and they can then argue for the treaty to be voided and terminated. Lastly, we will talk about the final issue, which is how do these competing principles like pacta sunt servanda, material breach, and jus cogens interact in this treaty situation. Now, this all depends on the legal hierarchy in international law that's been set up. Jus cogens norms are at the very top of the hierarchy. Now, what does this mean? Well, it means that jus cogens norms will triumph over all other principles, such as the material breach and pacta sunt servanda principle. Now, this was already established in Article 64, where if an existing treaty conflicts with a new jus cogens norms, the treaty will be voided and terminated. This principle is reaffirmed in the Armed Activities DRC and Rwanda case, where states can use treaty rules to get around the treaty obligations that are a jus cogens norm. Now, since pacta sunt servanda and material breach are all treaty rules, this principle applies to them as well. As discussed previously, if access to clean water can be linked to fundamental human rights, such as the right to life and health, then it will be considered a jus cogens norm, and thus treaty will be voided and terminated. If this argument succeeds, then the treaty will be terminated. This means that Aramika's argument that there was a material breach will be irrelevant, as there can be no breach if there isn't a treaty. However, if the argument that there is a jus cogens norms fail, then we will go down the hierarchy to pacta sunt servanda and its exceptions. Since Aramika's claim of material breach is much stronger compared to Botuna's weak defense of a fundamental change of circumstances, the material breach claim will prevail. Thus, the principle of pacta sunt servanda will be set aside due to this material breach exception, and Aramika's suspension of the treaty will be legally justified. Now we'll move on to the recommendations part. My first and stronger recommendation for Botuna and Aramika is that the parties should formally consent to suspend the treaty, which is allowed by Article 57 of VCRT 1969 for a few months. This will allow them time to come up with solutions without worrying about the treaty obligations that they will have to uphold. This would therefore align with the principles of pacta sunt servanda, as they are still trying to perform the treaty in good faith. Thus, at this time, they can discuss how to amend the treaty, which is allowed by Article 39 of the VCRT 1969, to ensure that environmental obligations are up to date with climate change impacts. The discussion on what to amend should be led by environmental scientists who are well equipped to advise the states on it. However, if this cooperative approach fails, then another strategy that I will recommend to Botuna is for them to continue arguing that access to clean water is a jus cogens norms. If they succeed, they will be able to get the treaty voided and terminated. Another option that the parties can opt for under Article 54 of the VCRT is that they can choose to terminate the treaty as long as both of them consent to it. This should only be considered if the parties are really serious in not wanting to continue this treaty relationship with one another, as it would be a waste of money and time that was invested into building the dam. To conclude, Aramika's suspension of the treaty due to a material breach by Botuna is legal. Secondly, Botuna's defense of fundamental change in circumstances will fail. And now on to Botuna's second defense of jus cogens norms. While environmental obligations are not recognized as a jus cogens norms currently, that might change eventually due to its growing importance. Botuna can argue that access to clean water is a jus cogens norm if it is linked to fundamental human rights. And thirdly, the principles interact via a legal hierarchy where a jus cogens norm will triumph. But if the argument for it fails, then Aramika's claim of material breach will prevail.